Welcome to Environmental Law course, dear learner and viewer. In continuation to the discussion on the regulation of hazardous industries, substances and process, we have taken note of the international legal development and as well as we have taken note of the regulation of hazardous industries in India. Now we are going to discuss about the judicial response to hazardous waste in India, and we will be discussing in this lecture State 4, the judicial response to the regulation of the hazardous waste in India. Here we are trying to again impress upon the fact that ever since the Bhopal gas tragedy has taken place on 22nd and 3rd December 1984, and it has escaped methyl isocyanide from the Union Carbide India Limited factory in Bhopal, the government swung into action about the regulation of hazardous industry. Secondly, that whatever happened, that it is supposed to be one of the biggest catastrophe in the world after the 3 Miles Island in USA and the Chernobyl nuclear disaster in erstwhile Russia. The Indian catastrophe of the escape of methyl cyanide from the plant of Union Carbide India Limited in Bhopal have taken more than 3,000 to 4,000 deaths, and it has caused severe mutagenic effect to other generations who have not dead but remained alive but are suffering from some kind of a dreaded diseases. Secondly, the entire population which is affected by the methyl isocyanide on the 2nd and 3rd December of 1984 is still languishing and having a trial and tribulation in relation to getting the compensatory justice. In the upshot of the argument here is that be that the Bhopal case or be that the oleum gas leak disaster case by the Shriram Food and Fertilizer Industry in Delhi, the idea here is that the Indian judiciary have taken a very bold step in creating the principles of absolute liability, so that it was decided in 1987 and Justice P.N. Bhagwati was of the view that this decision will serve as a precedent under Article 141 of the Constitution of India, which says that the law declared by the Supreme Court of India shall be binding on all the court, including the Supreme Court of India. And now the Union Carbide India Limited case was there because it has seen at many phases. It went to the government of India stand baffled as how to adopt the litigational strategy for the Bhopal victim, and then it filed a case in the New York South District where the Union Carbide India Limited was registered as a company. Then Justice Keaton, while hearing the case about the compensation in case of Bhopal, have rejected, saying that it is forum non-convenience, and the forum convenience happens to be the Indian court where the petitioner can agitate and claim the compensation. The experiences which has been learned was very sordid than why. Therefore, the government of India passed as a parent patry, passed a law Bhopal gas leak disaster within bracket processing of claim act in 1985, and on the strength of that case the government of India was able to file a litigation, because at that time the Environment Protection Act 1986 was not in the statute book, nor we had the hazardous waste management and handling rule on the statute book. Therefore, in the absence of these law, the law Bhopal gas leak disaster, Bhopal gas victims processing of claim act 1985 was the only law, and on the strength of that law it went to the Supreme Court. Since the Supreme Court, the matter was sub judice, Justice P.N. Bhagwati in his given wisdom thought that the decision, though the catastrophe in the oleum gas case was very minor, but Justice P.N. Bhagwati was of the firm view that the case which is in point is likely to come into the hearing, and the Supreme Court is going to decide about the liability of the multinational corporation in regard to the hazardous substances and hazardous processes and hazardous waste, including the liability of the Union Carbide India Limited plant in Bhopal. Will take note of the doctrine of absolute liability, which has been laid down by Justice P.N. Bhagwati, repudiating the doctrine of the strict liability and recognizing not a single exception to it. Thereafter, we see that the Bhopal case have not taken its due recognition and due cognizance of the law laid down by the Justice P.N. Bhagwati in the Shri Ram Food and Fertilizer M.C. Mehta vs. Union of India's case in 1987 in regard to the oleum gas cage and the principles of absolute liability, and have resulted into the travesty of the justice and a sellout, as many of the commentators have remarked about the pronouncement of the Bhopal case verdict. After that, we have seen the entire sphere of the international legal regime in relation to the regulation of the hazardous waste, and especially the three which appears to be very prominent and vociferous. The one is the Basel Convention, another happens to be the Rotterdam Convention, and the third happens to be the Stockholm Convention 2001. Taking all these three law into account and the three notifications and the rule framing of India in relation to the hazardous waste management and handling rule, hazardous waste import and export rule, hazardous waste in relation to storage and transportation rule, and its subsequent amendment in 2008, 2016, vis-a-vis the policy of the hazardous waste management policy 2008, environment policy 2006, and the disaster preparedness policy of the 2009. We are going to look at how this is going to affect the course and direction of the law and the evolution of law and justice in this law and justice in matters of regulation of the hazardous industry. The first case which comes into point is the Research Foundation for Science, Technology and the Natural Policy was a Union of India 1997. This case was filed by the Vandana Shiva, who heads this organization, have filed a petition regarding the effective legal framework on management of transboundary movement of hazardous waste. And this is the first case which have agitated in the context that India signed in 1992, although the India has also framed a law, the Basel Convention, which have reached its culmination in 1990, and India has ratified this on 1992. But some of the very finest point and provisions which has been engrafted into the Basel Convention on Transboundary Movement. Therefore, the petitioners sought the intervention of the Supreme Court regarding reading and religious reading of the Basel Convention and its application in Indian context. The issue remains that there has been an indiscriminate dumping of the hazardous waste, which have caused which has endangered the environment, flora, fauna, and human health. And this unchecked dumping of the hazardous waste was a source of agitation by this organization, and it has been argued very rightly that it also violate Article 14 and 21 of the Constitution, along with the Hazardous Waste Management and Handling Rule 1989. The Supreme Court decided that no authority shall grant permission to import the hazardous waste and prohibit it under the Basel Convention. Therefore, what has been laid down under the legal framework of hazardous waste management and handling rule 1989, and what has been laid down under the Basel Convention 1992, through which India has ratified it 1992, is the fact that authority shall grant permission to import of the hazardous waste prohibited under the Basel Convention, and this prohibition under the Basel Convention regarding any kind of granting permission of the import of the hazardous waste can be looked very rigorously, and it has also directed the state government, the government of Gujarat, the state government, Central Pollution Control Board, and the State Pollution Control Board to act against defaulting and unauthorized hazardous waste units which are accumulating and proliferating, creating a kind of a threat to environment and human health. Therefore, the state directed the report to take measures for closure of non-compliant unit into immediate effect. So, this law, which have hit hard to not only the hazardous waste management and handling rule 1989, after almost 5 to 7 years, the actual working of this law is being exposed by the petitioner, and try to see that how the proliferation of the hazardous waste and the import of waste are being carried out, and then it sought the intervention of the Supreme Court in order to protect the environment, flora, fauna, and health. and Supreme Court has very rapidly responded and have directed that whatever has been contained in the Basel Convention, India stand duty bound, and it is the pious obligation of the Indian government to see that the provision are not to be defied upon. With this case, we find another case of AP Pollution Control Board versus Professor M.V. Naidu. In this case, what happened that in hazardous manufacturing of the BSS grade castor oil and its derivative was likely to be located very near to what is called the two lakes in Hyderabad, supplying the Sikandrabad and Hyderabad, Himayat Sagar and Usman Sagar lakes. These two lakes were there, Usman Sagar and Himayat Sagar, and this divides also the twin city of Sikandrabad and the Hyderabad, taking note of the very glory of these two lakes, and considering that this lake happens to be one of the major source of the supply of the water to the common people and drinking water, then the Professor M.V. Naidu tried to see that how within the vicinity and the radius and of these two lakes, which in Hyderabad and Sikandrabad, are going to afford the establishment and manufacturing unit of the BSS grade castor oil derivatives, and that was challenged. The issue before the Supreme Court was that whether the industry could be permitted to operate despite potential risk to crucial water sources and water bodies and the historic Usman Sagar and the Himayat Sagar Lake. The National Environment Appellate Authority, as then it was in establishment, it has constituted expert bodies, and High Court found that industry is likely to produce hazardous byproduct, and the hazardous byproduct which is likely to produce, that was the report which has been submitted, and the submission of this report ultimately lead to the conclusion that the establishment of this industry is very harmful. The Supreme Court also tried to see the very provisions of Article 15 of the Rio Declaration, which has emphasized to apply the principle of precaution or the precautionary principle, which is inbuilt in Rio Declaration section principle 15 of the Rio Declaration 1992. And it also states that the industry which is going to establish the hazardous processes of manufacturing of the BSSS grade castor oil derivative has to discharge the burden of proof, saying that the developer alone know that whether it is hazardous or they have taken all reasonable care to see that Usman Sagar and Himayat Sagar lake are not to be polluted and it remains environmentally safe. Thus, we see that this case is of a great importance from the point of view of the precautionary approach, and as well as this case dealing with the location of a hazardous industry in the near the water bodies have also resulted into a great agitation by the Supreme Court, and saying the case speaking to Justice S. Jagannatha Rao has laid down the ruling that we require an environmental court because it is very difficult for the court of law to examine whether this industry is environmentally benign or environmentally malign. So, whether the environment friendliness of this industry is something in the interest of these two lakes or not. So, on and off that this Supreme Court is coming to the question of the scientific evidences, and it is the scientific evidences which have a propensity and have a preponderance to decide whether these industries are going to be established. Having given the ruling about the health and the survival of these two lakes of Usman Sagar and Himayat Sagar, and forbidding the location of this industry, the Supreme Court expressed displeasure about the scientifically rich report of the many experts and counter experts, which a group of experts saying that it is environmentally not harmful, some group is saying it is environmentally harmful. So, it is very difficult to take a line in between and to reach to a conclusion. So, time has come to see that there should be environmental court, and moreover the people's faith in the judiciary can remain intact when there is an environmental court, and thus besides ruling about the establishment of the hazardous industry within the vicinity of the two lakes Usman Sagar and Himayat Sagar in Hyderabad and Sikandrabad, the case is a pointer to the fact that we require an environmental court. Then the court has also applied a very novel principle of Wednesbury review, and that Wednesbury review in this case is very important. We try to see all the state action in a very critical parlance, and therefore this case has two more takeaways, one in relation to the environmental court and one in relation to the Wednesbury review. With this, we see the other case on the point which directly coming to the constitutionality and the legality and the veracity of the Rule 323 of the Hazardous Management and Handling Rule in regard to handling and disposal of the used oil for refining and processing. The rule pertains to recycling of the waste oil through methods like heating, like filtering, like settling, like centrifuging, and dehydration. And this kind of a process, which has been mentioned under Rule 323 of the Hazardous Waste Management and Handling Rule 1989, the core issue of the agitation was that the possession and handling of the hazardous substances without due care caused ecological harm and impacted potable water supply, and that is very important, that one, the potable water quality which are going to be affected, and the general impact on the health. Therefore, the Andhra Pradesh High Court emphasized that the strict compliance of Rule 3 subclause 23 of the Hazardous Waste Management Rule to be enforced in letter and spirit, and directed the State Pollution Control Board to cancel all kind of authorization and those engaged in unauthorized handling of the hazardous waste. It also reinforced the need for environmentally sound management, including proper facilities for the storage, treatment, and safe disposal of the hazardous waste. With this, we see that the K. Purushottam Reddy versus Union of India is again coming. A case in point happens to Andhra Pradesh High Court, and the court have seen that the rules of 3.3 subclause 23 should not be violated and to be strictly enforced, beside a Space Pollution Control Board to cancel the authorization and chalking out a very detailed policy for proper storage and treatment and safe disposal of the hazardous waste, be that the handling of the used oil or refining or reprocessing or whatever hazardous waste management and handling rule have prescribed. In case of Hindustan Coca-Cola Beverages versus Perumatti Grama Panchayat in 2005, the case in point is a very important, where the court have come very heavily against the Kerala State Pollution Control Board. The background of the case was there was a complaint which arose about the skin diseases, toxic effluent, and groundwater depletion in Kerala because of the Coca-Cola plant in Kerala have extracted indiscriminate amount of water from the aquifer, and the indiscriminate use by the law which is known as eminent domain, and this is the law which governs the groundwater extraction. So the law of the eminent domain but does not allow that extraction of the water, which should be very in an indiscriminate manner. And what happened, the Coca-Cola plant in Kerala have extracted large amount of the water, and therefore it left the groundwater depletion, and as well as the water table was not in a position to produce potable water, and therefore it result that it given rise to skin diseases. Moreover, the toxic effluent was also percolated down to the aquifer and the ground table, and the groundwater still remains contaminated. Therefore, the panchayat has a duty to protect the public health and as well as the water resources which they are being commanded. Kerala High Court raised concern. Kerala State Pollution Control Board also raised concern about the excess groundwater extraction, and so much so that not only the excess indiscriminate extraction of the water resources have taken place, it has also created heaps of hazardous waste generation. Therefore, the Supreme Court Monitoring Committee in 2003 investigated the matter at a greater length and breadth and directed the company to supply drinking water to the affected villages as a way of punishment. It also talks about that the Joint Parliamentary Committee recommended stopping groundwater extraction because the eminent domain at no point of time gives liberty and license to to indiscriminate pumping of the water from the aquifer and also indulge into the hazardous manufacturing. Therefore, both the Joint Parliamentary Committee and the Supreme Court Monitoring Committee have applied the principles of the Basel Convention 1989 and order that the repatriation of imported waste to countries like Germany and Ireland. This remains very important, and this remains very salutary judgment in the case of not only the indiscriminate pumping of the water from the aquifer as well as the generation of the hazardous waste and the complaint of the Perumatti Grama Panchayat in 2005 in a famous case of Hindustan Coca-Cola Beverages Limited. The outcome of this case happens to be that the Kerala State Pollution Control Board refused authorization to Coca-Cola under the Hazardous Waste Management and Handling Rule, and the Supreme Court Monitoring Committee suggested closure or reform the factory by taking the which lack the effluent treatment plant, and as well as the Hindustan Insecticide Limited and Travancore Titanium Limited, both industry were also clubbed together in this petition and has given direction that these industrial unit along with the 32 major industries which has been indulged into the pernicious tendency of the hazardous waste generation are to be closed down. Thus, the key takeaways of this case happens to be that it reinforced the principles of accountability for the industrial pollution along with the hazardous waste management under the environmental law, and it also tried to repose confidence in the Basel Convention, to which India happens to be the party. Having seen the outcome of the Hindustan Coca-Cola Beverages case versus Piramutti Grama Panchayat in 2005, now we turn to Rajiv Narayan versus Union of India, was a decision of 1215 by the National Green Tribunal. The case in point deals with the water pollution which has been caused by the Rathi Steel and Power Limited in Ghaziabad, and the petitioner was a local resident, has complained that the black smoke emission poisoning serious health risk in Ghaziabad in UP, very adjoining to the national capital region and Delhi. The industry was found to have inadequate permission for the groundwater extraction and as well as the authorization of hazardous waste handling. So on both the count, the authorization of the hazardous waste handling and the permission for extraction of the groundwater, in both the cases, the industry was found to be on the wrong side of the law. Therefore, the finding happens to be in this case by the NGT that since it operated without consent of the Pollution Control Board and failed to install pollution control devices for the air and water emission, the NGT issued a show cause and directed the company to pay compensation for pollution and restore the entire environment, and directed for the restoration of environment and compliance with the statutory norm of the Schedule 7 of the Hazardous Waste Rule 1989, and it directed the Ministry of Environment, Forest, Central Pollution Control Board, State Pollution Control Board, Director General of Factory, Custom and Port to see that how this role of the Schedule 7 of the Hazardous Waste Rule can be activated and can be applied in all kind of industries which are generating some kind of the hazardous waste. Then in another case known as Suamoto versus Vatwa Industry Association by the Gujarat High Court in 2000, the Gujarat High Court took Suamoto cognizance of unauthorized waste movement and the dumping of the hazardous waste, and it directed the Pollution Control Board that instead of exercising its authority, the court termed that there is a dereliction of duty on and the failure of the statutory authority to take the responsibility of unauthorized hazardous waste movement and dumping. And it also noted that the environmental law grants broad enforcement power to the Pollution Control Board and criticized that there has been a kind of a callous attitude and very indifferent attitude, and directed the State Pollution Control Board to take immediate measure and firm action against the polluting units, and warned that if that dereliction of the duty continues and the illegal dumping remain unchecked, then the court will come very heavily and will issue some strictures and some kind of a contempt in this case to bring compliance in regard to the hazardous waste movement and dumping. In Research Foundation versus Union of India in 2003, in this case relate to the import of 133 containers of the waste oil, which is falsely declared as a lubricating oil. It was a false declaration, and on the basis of that, the Supreme Court issued notices to the importer to show cause as to why the consignment should not be re-exported and destroyed at their own cost, and in likely to be invoked the polluter pays principle for bringing such import of 133 containers of the waste oil in the facade and in the cloak of having lubricating oil, and have applied the polluter pays principle in this case to recover the cost, and directed the Commissioner of Custom to determine if the import qualified as hazardous waste under the Basel Convention, then it is necessary that Supreme Court order the destruction of all 13 containers by incineration, and Supreme Court under the supervision of Supreme Court Monitoring Committee. And this case is very important because this organization, as we have seen in the earlier case of the first case on the point, Research Foundation for Science and Technology and National Resource Policy, which hit hard for the effective legal framework of the transboundary movement of the hazardous waste in Gujarat. And now in this case also, we try to see the same kind of the court's response. It was a case of 1997, where this case pertains to 2003, and where 133 containers were ultimately asked to be incinerated under the supervision of the Supreme Court Monitoring Committee in order to have to save any kind of any illegal entry of the hazardous waste and strict regulatory compliance in terms of hazardous waste management rule and as well as the Basel Convention. In case of Sterlite Industries Limited versus Union of India in 2013, the fact of the case remains that a copper smelter plant in Sterlite industry at Tuticorin in Tamil Nadu have resulted into some kind of the failure of pollution control devices. Therefore, the Madras High Court has ordered the closure of plant and awarded retrenchment compensation to the employee under section 25 triple F of the industrial dispute. And this is a kind of analogy which has been adopted by in cases of the MC Mehta versus Union of India, where 168 hazardous industries in Delhi was closed by the Supreme Court, and Supreme Court, while closing this industry, has given an option to the industry to relocate into the sparsely populated area, meaning thereby all the 4 estates adjoining to Delhi or relocate or shift the industry and or give compensation to the worker by giving a notice, the retrenchment compensation, and retrench their employees because of the closure of industry. So in this case also, this is a kind of a mechanism which has been adopted in many cases. In cases of relocation of the industry and the closure of industry, that the compensation under the section 25 triple F was paid under this under Industrial Dispute Act, and we see the same decision in the Sterlite Industries India Limited versus Union of India in 2013, and the Supreme Court Monitoring Committee on Hazardous Waste 2004 found that there is an arsenic burning waste dump and phosphogypsum mound and excessive sulfur dioxide emission in this case, and the effluent treatment plant and the waste disposal facilities were considered to be highly unsatisfactory and inadequate and failed the Central Pollution Control Board norm. In this case, there was no option to deal with the cases of the hazardous waste in Tamil Nadu in reference to the Sterlite Industries at Tuticorin in Tamil Nadu, but to declare the closure of industry and asked an exit policy of the worker by paying compensation, retrenchment compensation under Industrial Dispute Act. The another case in point happens to be that whatever the issue which was involved in this case of Sterlite industry, we find the Supreme Court upheld the need for strict compliance of the environmental norm and wanted to have an independent audit along with the Central Pollution Control Board, Tamil Nadu Pollution Control Board, and it recognized the need and findings of the Supreme Court Monitoring Committee and have to draw a long-term monitoring rather than case-to-case basis and declare indefinite closure of the industry without bothering about their implications on the revenue and the economy and unemployment, and try to bring more accountability and environmental restitution. The case also have given rise to what large-scale mismanagement which has been happening in case of dumping of 77,000 tons of toxic hexavalent chromium in HEMA chemicals. That is also a case in point from the Gujarat, that this case of HEMA chemical case, that is something very important to be understood. And then in case of Aventis Pharma case, that it was found that non-functioning of the common effluent treatment plant and violation of the hazardous waste rule. So we see that whatever has happened in case of the decision of the Sterlite company and as well as the Research Foundation case and Suamoto Vatva Industries case in Gujarat, most of these cases are coming from the jurisdiction of the Gujarat because there is a proliferation and congregation of the pharma industry. So in case of Aventis Pharma, in case of Hema Chemicals Limited, in both the cases, the Supreme Court Monitoring Committee 2003 undertook extensive action in Gujarat, in one of the India's most hazardous waste affected states. Thus, we see that right from the Tamil Nadu, Kerala, Gujarat, we have a case in point from the Goa, and Goa's Zori Industries case is very important to be considered, where 100 tons of arsenic contaminated was found to be mixed in the concrete and in the hermit storage, and the committee further mandated that all hazardous units to be publicly displayed, display board showing authorized emission, affluent, and adverse publicity. And then we see that in most of the cases, whether in Maharashtra, whether in Goa, whether in Gujarat, whether in Kerala, whether in Tamil Nadu, the case happens to brought before the notice of the Supreme Court by the Supreme Court's its own deeper commitment in order to see the regulation of the hazardous industries and containing all the indiscriminate dumping of the hazardous waste. Thus, we see that in Telangana, Madhya Pradesh, Delhi, we find a large number of the Greenpeace International model of cleaning of 20 years old waste in the Union Carbide India Limited was applied in case of Telangana, in case of Madhya Pradesh, in case of Delhi, and finally the Supreme Court ordered closure of 957 industries, hazardous waste generating industry, which were in and around Delhi, and mostly these units happens to be in the area of densely populated area in Telangana, where there is a contamination from the arsenic, mercury, and chromium waste. Then the Supreme Court committee also come very heavily against it. Then committee took cognizance in the local area environment committee in the Andhra Pradesh and the Madhya Pradesh, looking at the entire map of the India. Either it is Madhya Pradesh or Telangana or Delhi, we find that the Supreme Court Monitoring Committee has resulted into containment of the hazardous waste, be that Goa, be that Maharashtra, be that Gujarat, be that Tamil Nadu, be that Kerala, be that uh, any part of the India. We see the representation of, be that the Andhra Pradesh, Telangana, and we see that the regulation of the hazardous waste in terms of judicial response, we find an all India, the pan India violation of the hazardous waste, but mostly we see that few examples from the eastern India or the northern India, except the Delhi, we find most of the cases are coming from the Gujarat, Tamil Nadu, Kerala, Andhra, Maharashtra, Goa, Madhya Pradesh, and we see that the entire geographical mapping of the proliferation of the hazardous waste, then the Supreme Court have taken a very salutary impact, and through its series of judicial responses across India, it has set to see that the regulation of the hazardous substances and process in India should be fully stand compliant with the Basel Convention, Rotterdam Convention, Stockholm Convention, vis-a-vis the Environment Protection Act, as well as the 3 notification on the hazardous waste in India. With this, I thank and I wish you happy learning.